This is video 2 in a Miami Condo Investing Club series on House Bill 913 Condominium and Cooperative Associations from the 2025 Florida Legislative Session. Topic: Pages 9 through 26 of the comprehensive 92-page House Bill 913 PDF document released by the Florida Legislature. Introduction. Florida is set to implement changes to the state's overarching condo law beginning July 1, 2025. This new legislation, dubbed House Bill 913 or HB 913, aims to assist cash-strapped condo owners to adapt to the changes being implemented as a result of the tragic Surfside condo collapse in June 2021, when nearly 100 people died and a $1 billion settlement was paid out to the families of the victims. The legislation was passed on April 30, 2025, and signed into law by Florida Governor Ron DeSantis on June 23, 2025. In our effort to stay abreast of the latest trends, opportunities, and challenges in the South Florida condo market, we at the Miami Condo Investing Club have obtained a copy of the new legislation, which is available from the Florida Legislature's website as a comprehensive 92-page PDF document. We plan to make a series of videos highlighting the new legislation for educational purposes. All of our videos will feature AI-generated audio based on the voice of Peter Zaleski, the founder of the Miami Condo Investing Club, reading aloud the legislation verbatim. We hope that our videos will provide viewers and listeners alike a convenient way to listen on demand to the revisions while doing other things, including cooking, exercising, or even gardening. Please note, each video will be less than 60 minutes long in order to facilitate distribution on our website of Miami Condo Club, as well as on popular social media networks. It is also worth noting we will do our best to start and stop the videos based on related topics. However, it is possible that the videos at times may jump around from one topic to another. If this happens, please remember our videos are exact readouts of the text of the House Bill 913 PDF document. This video, the second in our series, features pages 9 through 26 of the comprehensive 92-page House Bill 913 PDF document. The text was copied directly from the PDF document and pasted into this video file. No editing was made to the text to create this video. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. If you are seeking independent information, critical analysis, or proprietary research about the South Florida condo market, we would encourage you to consider joining the Miami Condo Investing Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. More information on the club is available at Miami Condo Club. We hope you enjoy video 2 in our series on Florida House Bill 913. This is a readout of pages 9 through 26 of the 92-page House Bill 913 PDF document released by the Florida Legislature. Begin. Be it enacted by the Legislature of the State of Florida, Section 1. Paragraph H is added to subsection 2 of Section 468.432 Florida statutes, and subsection 3 is added to that section to read 468.432 licensure of community association managers and community association management firms. Exceptions. To a community association management firm or other similar organization responsible for the management of more than 10 units or a budget of $100,000 or greater shall not engage or hold itself out to the public as being able to engage in the business of community association management in this state, unless it is licensed by the department as a community association management firm in accordance with the provisions of this part. H. A person who has had his or her community association manager license revoked may not have an indirect or direct ownership interest in or be an employee, a partner, an officer, a director, or a trustee of a community association management firm during the 10-year period after the effective date of the revocation. Such person is ineligible to reapply for certification or registration under this part for a period of 10 years after the effective date of a revocation. 3. A licensee must create and maintain an online licensure account with the department. Each community association manager must identify on his or her online licensure account the community association management firm for which he or she provides management services and identify each community association for which he or she is the designated on-site community association manager. A licensee must update his or her online licensure account with this information within 30 days after any change to the required information. A community association management firm must identify on its online licensure account the community association managers that it employs to provide community association management services. If a community association manager has his or her license suspended or revoked, the department must give written notice of such suspension or revocation to the community association management firm and the community association for which the manager performs community management services. Section 2. Subsections 1 and 3 of Section 468.4334 Florida statutes are amended to read 468.4334 Professional Practice Standards, Liability, Community Association Manager Requirements, Return of Records after termination of contract. 1A. A community association manager or a community association management firm is deemed to act as agent on behalf of a community association as principal within the scope of authority authorized by a written contract or under this chapter. A community association manager or a community association management firm may not knowingly perform any act directed by the community association if such an act violates any state or federal law. A community association manager and a community association management firm shall discharge duties performed on behalf of the association as authorized by this chapter loyally, skillfully, and diligently, dealing honestly and fairly, in good faith, with care and full disclosure to the community association, accounting for all funds, and not charging unreasonable or excessive fees. B. If a community association manager or a community association management firm has a contract with a community association that is subject to the milestone inspection requirements in S. 553.899 or the structural integrity reserve study requirements in S. 718.1122G and 719.1061K, the community association manager or the community association management firm must comply with those sections that section as directed by the board. C. Each contract between a community association and a community association manager or community association management firm for community association management services must include the following written statement in at least 12-point type if applicable to the type of management services provided in the contract. The community association manager shall abide by all professional standards and record-keeping requirements imposed pursuant to Part Roman 8 of Chapter 468 Florida statutes. D. A contract between a community association manager or community association management firm and a community association may not waive or limit the professional practice standards required pursuant to this part. 3. A community association manager or community association management firm that is authorized by contract to provide community association management services to a community association shall do all of the following. Attend in person at least one member meeting or board meeting of the Community Homeowners Association annually. B. Provide to the members of the community association the name and contact information for each community association manager or representative of a community association management firm assigned to the community association, the manager's or representative's hours of availability, and a summary of the duties for which the manager or representative is responsible. The community association shall also post this information on the association's website or mobile application. If the association is required to maintain official records on a website or application, the community association manager or community association management firm shall update the community association and its members within 14 business days after any change to such information. C. Provide to any member upon request a copy of the contract between the Community Association Manager or Community Association Management Firm and the Community Association and include such contract with Association's official records. Section 3. Section 468.4335 Florida Statutes is amended to read 468.4335 Conflicts of Interest. 1. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, must disclose to the board of a community association any activity that may reasonably be construed to be a conflict of interest. A rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, proposes to enter into a contract or other transaction with the association or enters into a contract for goods or services with the association for services other than community association management services. Be a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, holds an interest in or receives compensation from a person as defined in S. 1.013, which conducts business with the association or proposes to enter into a contract or other transaction with the association. As used in this paragraph, the term compensation means any referral fee or other monetary benefit derived from a person as defined in S. 1.013, which provides products or services to the association, and any ownership interests or profit-sharing arrangements with product or service providers recommended to or used by the association. 2. If the association receives and considers a bid that exceeds $2,500 to provide a good or service, other than community association management services, which is or may reasonably be construed to be a conflict of interest under subsection 1, the association must solicit multiple bids from other third-party providers of such goods or services. This subsection does not apply to any activities or the provision of goods or services that are disclosed in the management services contract as a conflict of interest within the meaning of subsection 1. 3. If a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, proposes to engage in an activity that is a conflict of interest as described in subsection 1, the proposed activity must be listed on the meeting agenda of the next Board of Administration meeting. The notice for the meeting at which the proposed activity will be considered by the board must include a description of the proposed activity, disclose the possible conflict of interest, and include a copy of all contracts and transactional documents related to the proposed activity. The disclosures of a possible conflict of interest must be entered into the written minutes of the meeting. Approval of the contract, including a management contract between the community association and the community association manager or community association management firm, or other transaction requires an affirmative vote of 2/3 of all directors present. If a community association manager or community association management firm has previously disclosed a conflict of interest in an existing management contract entered into between the board of directors and the community association manager or community association management firm, the conflict of interest does not need to be additionally noticed and voted on during the term of such management contract, but upon renewal must be noticed and voted on in accordance with this subsection. 4. If the board finds that a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, has violated this section, the contract is voidable and the association may terminate, cancel its community association management contract with the community association manager or the community association management firm by delivery of a written notice terminating the contract. If the contract is terminated, the association is liable only for the reasonable value of the management services provided up to the time of cancellation and is not liable for any termination fees, liquidated damages, or other form of penalty for such cancellation. 5 is used in this section. The term relative means a relative within the third degree of consanguinity by blood or marriage. Section 4. Present subsections 12 and 13 of Section 553.899 Florida statutes are redesignated as subsections 14 and 15, respectively. New subsections 12 and 13 are added to that section, and paragraph of subsection 3 and subsection 11 of that section are amended to read 553.899 mandatory structural inspections for condominium and cooperative buildings. 3 of an owner or owners of a building that is 3 habitable stories or more in height as determined by the Florida Building Code and that is subject in whole or in part to the condominium or cooperative form of ownership as a residential condominium under Chapter 718 or a residential cooperative under Chapter 719 must have a milestone inspection performed by December 31st of the year in which the building reaches 30 years of age, based on the date the certificate of occupancy for the building was issued, and every 10 years thereafter. If a building reached 30 years of age before July 1st, 2022, the building's initial milestone inspection must be performed before December 31st, 2024. If a building reaches 30 years of age on or after July 1st, 2022, and before December 31st, 2024, the building's initial milestone inspection must be performed before December 31st, 2025. If the date of issuance for the certificate of occupancy is not available, the date of issuance of the building's certificate of occupancy shall be the date of occupancy evidenced in any record of the local building official. 11. A Board of County Commissioners or municipal governing body shall may adopt an ordinance requiring that a condominium or cooperative association and any other owner that is subject to this section schedule or commence repairs for substantial structural deterioration within a specified time frame after the local enforcement agency receives a Phase 2 inspection report. However, such repairs must be commenced within 365 days after receiving such report. If an owner of the building fails to submit proof to the local enforcement agency that repairs have been scheduled or have commenced for substantial structural deterioration identified in a Phase 2 inspection report within the required time frame, the local enforcement agency must review and determine if the building is unsafe for human occupancy. 12. A licensed architect or engineer who bids to perform a milestone inspection must disclose in writing to the association his or her intent to bid on any services related to any maintenance, repair, or replacement which may be recommended by the milestone inspection. Any design professional as defined in S. 558.02 or contractor licensed under Chapter 489 who submits a bid to the association for performing any services recommended by the milestone inspection may not have an interest, directly or indirectly, in the firm or entity providing the milestone inspection, or be a relative of any person having a direct or indirect interest in such firm, unless such relationship is disclosed to the association in writing. As used in this section, the term relative means a relative within the third degree of consanguinity by blood or marriage. A contract for services is voidable and terminates upon the association filing a written notice terminating the contract if the design professional or licensed contractor failed to provide the written disclosure of the relationship required under this subsection. A design professional or licensed contractor may be subject to discipline under the applicable Practice Act for his or her profession for failure to provide the written disclosure of the relationship as required under this subsection. 13. On or before December 31st, 2025, and on or before each December 31st thereafter, the local enforcement agency responsible for milestone inspections shall provide the department in an electronic format determined by the department information that must include, but is not limited to: 1. The number of buildings required to have a milestone inspection within the agency's jurisdiction. 2. The number of buildings for which a Phase 1 milestone inspection has been completed. 3. The number of buildings granted an extension under paragraph 3C. 4. The number of buildings required to have a Phase 2 milestone inspection. 5. The number of buildings for which a Phase 2 milestone inspection has been completed. 6. The number, type, and value of permit applications received to complete repairs required by a Phase 2 milestone inspection. 7. A list of buildings deemed to be unsafe or uninhabitable as determined by a milestone inspection. 8. The license number of the building code administrator responsible for milestone inspections for the local enforcement agency. B. The department shall provide to the Office of Program Policy Analysis and Government Accountability (OPAGA) all information obtained from the local enforcement agencies under paragraph by the dates specified and in a manner prescribed by OPAGA. OPAGA may request from a local enforcement agency any additional information necessary to compile the information and provide a report to the President of the Senate and the Speaker of the House of Representatives. Section 5. Present subsections 33 and 34 of Section 718.103 Florida statutes are redesignated as subsections 34 and 35, respectively. A new subsection 33 is added to that section, and subsection 1 of that section is amended to read 718.103 definitions. As used in this chapter, the term 1. Alternative funding method means a method approved by the Division for funding the capital expenditures and deferred maintenance obligations for a multi-condominium association, which may reasonably be expected to fully satisfy the association's reserved funding obligations by the allocation of funds in the annual operating budget. 33. Video conference means a real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. The notice for any meeting that will be conducted by video conference must have a hyperlink and call and conference telephone number for unit owners to attend the meeting and must have a physical location where unit owners can also attend the meeting in person. All meetings conducted by video conference must be recorded, and such recording must be maintained as an official record of the association. Section 6. Subsections 4 and 10 of Section 718.110 Florida statutes are amended to read 718.110 Amendment of Declaration, correction of error or omission in declaration by Circuit Court. 4 is subject to paragraph B unless otherwise provided in the declaration as originally recorded, and no amendment may not change the configuration or size of any unit in any material fashion, materially alter or modify the appurtenances to the unit, or change the proportion or percentage by which the unit owner shares the common expenses of the condominium and owns the common surplus of the condominium, unless the record owner of the unit and all record owners of liens on the unit join in the execution of the amendment, and unless all the record owners of all other units in the same condominium approve the amendment. The acquisition of property by the association and material alterations or substantial additions to such property or the common elements by the association in accordance with S. 718.1117 or S. 718.113 and amendments providing for the transfer of use rights in limited common elements pursuant to S. 718.1062b may not be considered material alteration or modification of the appurtenances to the units. Except as provided in paragraph B, a declaration recorded after April 1, 1992, may not require the approval of less than a majority of total voting interests of the condominium for amendments under this subsection, unless otherwise required by a governmental entity. B. Notwithstanding subsection 14, the declaration of a non-residential condominium formed on or after July 1, 2025 may be amended to change the configuration or size of a unit in any material fashion, materially alter or modify the appurtenances to the unit, or change the proportion or percentage by which the unit owner shares the common expenses of the condominium and owns the common surplus of the condominium, if the record owners of all affected units and all record owners of liens on the affected units join in the execution of the amendment. The approval of the record owners of the non-affected units in such condominium is not required. 10. If there is an omission or error in a declaration of condominium or any other document required to establish the condominium, and the omission or error would affect the valid existence of the condominium, The circuit court may entertain a petition of one or more of the unit owners in the condominium or of the association to correct the error or omission, and the action may be a class action. The court may require that one or more methods of correcting the error or omission be submitted to the unit owners to determine the most acceptable correction. All unit owners, the association, and the mortgagees of a first mortgage of record must be joined as parties to the action. Service of process on unit owners may be by publication, but the plaintiff must furnish every unit owner not personally served with process with a copy of the petition and final decree of the court by certified mail, return receipt requested, at the unit owner's last known residence address as reflected in the association's official records. If an action to determine whether the declaration or another condominium document complies with the mandatory requirements for the formation of a condominium is not brought within 3 years of the recording of the certificate of a surveyor and mapper pursuant to S. 718.1044E, or the recording of an instrument that transfers title to a unit in the condominium, which is not accompanied by a recorded assignment of developer rights in favor of the grantee of such unit, whichever occurs first, the declaration and other documents will effectively create a condominium, as of the date the declaration was recorded, regardless of whether the documents substantially comply with the mandatory requirements of law. However, both before and after the expiration of this 3-year period, the Circuit Court has jurisdiction to entertain a petition permitted under this subsection for the correction of the documentation, and other methods of amendment may be utilized to correct the errors or omissions at any time. Section 7. Paragraph A of subsection 11, paragraphs C and G of subsection 12, and subsection 13 of section 718.111 Florida statutes are amended. Paragraphs G, H, and I are added to subsection 3 of that section, and subsection 16 is added to that section to read 718.111 the association. 3. Power to manage condominium property and to contract, sue, and be sued. Conflict of interest. G. If an association contracts with a community association manager or a community association management firm, the community association manager or community association management firm must possess all applicable licenses required by Part Roman 8 of Chapter 468. All board members or officers of an association that contracts with a community association manager or a community association management firm have a duty to ensure that the community association manager or community association management firm is properly licensed before entering into a contract. H. If a contract is between a community association manager and the association, and the community association manager has his or her license suspended or revoked during the term of a contract with the association may terminate the contract upon delivery of a written notice to the community association manager whose license has been revoked or suspended, effective on the date the community association manager became unlicensed. I. If a community association management firm has its license suspended or revoked during the term of a contract with the association may terminate the contract upon delivery of a written notice to the community association management firm whose license has been revoked or suspended, effective on the date the community association management firm became unlicensed. 11. Insurance. In order to protect the safety, health, and welfare of the people of this state, and to ensure consistency in the provision of insurance coverage to condominiums and their unit owners, this subsection applies to every residential condominium in this state, regardless of the date of its declaration of condominium. It is the intent of the legislature to encourage lower or stable insurance premiums for associations described in this subsection. Every condominium association shall have adequate property insurance as determined under this paragraph, regardless of any requirement in the declaration of condominium for certain coverage by the association. 1. An association or group of associations may provide adequate property insurance as determined under this paragraph through a self-insurance fund that complies with the requirements of SS 624.460, 624.488. 2. The amount of adequate insurance coverage for full insurable value, replacement cost, or similar coverage may be based on the replacement cost of the property to be insured, as determined by an independent insurance appraisal or an update of a previous appraisal. The replacement cost must be determined at least once every 3 years at minimum. 3. The association's obligation to obtain and provide adequate property insurance coverage for a group of at least 3 communities created and operating under this chapter, Chapter 719, Chapter 720, or Chapter 721 may be satisfied by obtaining and maintaining for such communities insurance coverage sufficient to cover an amount equal to the probable maximum loss for the communities for a 250-year windstorm event. A. Such probable maximum loss must be determined through the use of a competent model that has been accepted by the Florida Commission on Hurricane Loss Projection Methodology. B. A policy or program providing such coverage may not be issued or renewed after July 1, 2008, unless it has been reviewed and approved by the Office of Insurance Regulation. The review and approval must include approval of the policy and related forms pursuant to SS 627.410 and 627.411, approval of the rates pursuant to S 627.062. A determination that the loss model approved by the Commission was accurately and appropriately applied to the insured structures to determine the 250-year probable maximum loss, and a determination that complete and accurate disclosure of all material provisions is provided to condominium unit owners before execution of the agreement by a condominium association. 4. When determining the adequate amount of property insurance coverage, the association may consider deductibles as determined by this subsection. 12. Official records. From the inception of the association shall maintain each of the following items, if applicable, which constitutes the official records of the association. 1. A copy of the plans, permits, warranties, and other items provided by the developer under S. 718.3014. 2. A copy of the recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. 3. A copy of the recorded bylaws of the association and each amendment to the bylaws. 4. A certified copy of the articles of incorporation of the association or other documents creating the association and each amendment thereto. 5. A copy of the current rules of the association. 6. A book or books or electronic records that contain the minutes of all meetings of the association, the Board of Administration, any committee, and the unit owners, and a recording of all such meetings that are conducted by video conference. If there are approved minutes for a meeting held by video conference, recordings of meetings that are conducted by video conference must be maintained for at least 1 year after the date. The video recording is posted as required under paragraph G. 7. A current roster of all unit owners and their mailing addresses, unit identifications, voting certifications, and if known, telephone numbers. The association shall also maintain the email addresses and facsimile numbers of unit owners consenting to receive notice by electronic transmission. In accordance with subparagraph C5. E. The email addresses and facsimile numbers are only accessible to unit owners if consent to receive notice by electronic transmission is provided, or if the unit owner has expressly indicated that such personal information can be shared with other unit owners and the unit owner has not provided the association with a request to opt out of such dissemination with other unit owners. An association must ensure that the email addresses and facsimile numbers are only used for the business operation of the association and may not be sold or shared with outside third parties. If such personal information is included in documents that are released to third parties other than unit owners, the association must redact such personal information before the document is disseminated. However, the association is not liable for an inadvertent disclosure of the email address or facsimile number for receiving electronic transmission of notices, unless such disclosure was made with a knowing or intentional disregard of the protected nature of such information. 8. All current insurance policies of the association and condominiums operated by the association. 9. A current copy of any management agreement, lease, or other contract to which the association is a party or under which the association or the unit owners have an obligation or responsibility. 10. Bills of sale or transfer for all property owned by the association. 11. Accounting records for the association and separate accounting records for each condominium that the association operates. Any person who knowingly or intentionally defaces or destroys such records, or who knowingly or intentionally fails to create or maintain such records with the intent of causing harm to the association or one or more of its members, is personally subject to a civil penalty pursuant to S. 718.5011E. The accounting records must include, but are not limited to: A. Accurate, itemized, and detailed records of all receipts and expenditures, including all bank statements and ledgers. B. All invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association. C. A current account and a monthly, bimonthly, or quarterly statement of the account for each unit designating the name of the unit owner, the due date and amount of each assessment, the amount paid on the account, and the balance due. D. All audits, reviews, accounting statements, structural integrity reserve studies, and financial reports of the association or condominium. Structural integrity reserve studies must be maintained for at least 15 years after the study is completed. E. All contracts for work to be performed. Bids for work to be performed are also considered official records and must be maintained by the association for at least 1 year after receipt of the bid. 12. Ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by unit owners, which must be maintained for 1 year from the date of the election, vote, or meeting to which the document relates, notwithstanding paragraph B. 13. All rental records if the association is acting as agent for the rental of condominium units. 14. A copy of the current question and answer sheet as described in S. 718.504. 15. A copy of the inspection reports described in SS 553.899 and 718.3014P and any other inspection report relating to a structural or life safety inspection of condominium property. Such record must be maintained by the association for 15 years after receipt of the report. 16. Bids for materials, equipment, or services. 17. All affirmative acknowledgments made pursuant to S. 718.1214C. 18. A copy of all building permits. 19. A copy of all satisfactorily completed board member educational certificates. 20. A copy of all affidavits required by this chapter. 21. All other written records of the association not specifically included in the foregoing, which are related to the operation of the association. C1. A. The official records of the association are open to inspection by any association member and any person authorized by an association member as a representative of such member at all reasonable times. The right to inspect the records includes the right to make or obtain copies, at the reasonable expense, if any, of the member and of the person authorized by the association member as a representative of such member. A renter of a unit has a right to inspect and copy only the declaration of condominium, the association's bylaws and rules, and the inspection reports described in SS 553.899 and 718.3014P. The association may adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying, but may not require a member to demonstrate any purpose or state any reason for the inspection. The failure of an association to provide the records within 10 working days after receipt of a written request creates a rebuttable presumption that the association willfully failed to comply with this paragraph. A unit owner who is denied access to official records is entitled to the actual damages or minimum damages for the association's willful failure to comply. Minimum damages are $50 per calendar day for up to 10 days, beginning on the 11th working day after receipt of the written request. The failure to permit inspection entitles any person prevailing in an enforcement action to recover reasonable attorney fees from the person in control of the records who, directly or indirectly, knowingly denied access to the records. If the requested records are posted on an association's website or are available for download through an application on a mobile device, the association may fulfill its obligations under this paragraph by directing to the website or the application all persons authorized to request access. B. In response to a written request to inspect records, the association must simultaneously provide to the requester a checklist of all records made available for inspection and copying. The checklist must also identify any of the association's official records that were not made available to the requester. An association must maintain a checklist provided under this subparagraph for 7 years. An association delivering a checklist pursuant to this subparagraph creates a rebuttable presumption that the association has complied with this paragraph. 2. A director or member of the board or association or a community association manager who willfully and knowingly or intentionally violates subparagraph 1 commits a misdemeanor of the second degree, punishable as provided in S. 775.082 or S. 775.283 and must be removed from office and a vacancy declared. 3. A Y person who willfully and knowingly or intentionally defaces or destroys accounting records that are required by this chapter to be maintained during the period for which such records are required to be maintained, or who willfully and knowingly or intentionally fails to create or maintain accounting records that are required to be created or maintained with the intent of causing harm to the association or one or more of its members, commits a misdemeanor of the first degree, punishable as provided in S. 775.082 or S. 775.083, is personally subject to a civil penalty pursuant to S. 718.5011D and must be removed from office and a vacancy declared. 4. A person who willfully and knowingly or intentionally refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, commits a felony of the third degree, punishable as provided in S. 775.082 S. 775.083 or S. 775.084 and must be removed from office and a vacancy declared. 5. The association shall maintain an adequate number of copies of the declaration, articles of incorporation, bylaws and rules, and all amendments to each of the foregoing, as well as the question and answer sheet as described in S. 718.504 and the most recent annual financial statement and annual budget required under this section on the condominium property to ensure their availability to unit owners and prospective purchasers, and may charge its actual costs for preparing and furnishing these documents to those requesting the documents. An association shall allow a member or his or her authorized representative to use a portable device, including a smartphone, tablet, portable scanner, or any other technology capable of scanning or taking photographs to make an electronic copy of the official records in lieu of the association's providing the member or his or her authorized representative with a copy of such records. The association may not charge a member or his or her authorized representative for the use of a portable device. Notwithstanding this paragraph, the following records are not accessible to unit owners. A. Any record protected by the lawyer-client privilege as described in S. 90.502 and any record protected by the work product privilege, including a record prepared by an association attorney or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and which was prepared exclusively for civil or criminal litigation or for adversarial administrative proceedings, or which was prepared in anticipation of such litigation or proceedings until the conclusion of the litigation or proceedings. B. Information obtained by an association in connection with the approval of the lease, sale, or other transfer of a unit. C. Personnel records of association or management company employees, including but not limited to disciplinary, payroll, health, and insurance records. For purposes of this subparagraph, the term personnel records does not include written employment agreements with an association employee or management company, or budgetary or financial records that indicate the compensation paid to an association employee. D. Medical records of unit owners. E. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, emergency contact information, addresses of a unit owner other than as provided to fulfill the association's notice requirements, and other personal identifying information of any person, excluding the person's name, unit designation, mailing address, property address, and any address, email address, or facsimile number provided to the association to fulfill the association's notice requirements. Notwithstanding the restrictions in this subparagraph, an association may print and distribute to unit owners a directory containing the name, unit address, and all telephone numbers of each unit owner. However, an owner may exclude his or her telephone numbers from the directory by so requesting in writing to the association. An owner may consent in writing to the disclosure of other contact information described in this subparagraph. The association is not liable for the inadvertent disclosure of information that is protected under this subparagraph if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. F. Electronic security measures that are used by the association to safeguard data, including passwords. G. The software and operating system used by the association which allow the manipulation of data, even if the owner owns a copy of the same software used by the association. The data is part of the official records of the association. H. All affirmative acknowledgments made pursuant to S. 718.1214 CG1. By January 1, 2019, an association managing a condominium with 150 or more units which does not contain timeshare units shall post digital copies of the documents specified in subparagraph 2 on its website or make such documents available through an application that can be downloaded on a mobile device. Unless a shorter period is otherwise required, a document must be made available on the association's website or made available for download through an application on a mobile device within 30 days after the association receives or creates an official record specified in subparagraph 2. A. The association's website or application must be an independent website, application, or web portal wholly owned and operated by the association, or Roman II, a website, application, or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, collection of subpages or web portals, or an application which is dedicated to the association's activities and on which required notices, records, and documents may be posted or made available by the association. B. The association's website or application must be accessible through the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to unit owners and employees of the association. C. Upon a unit owner's written request, the association must provide the unit owner with a username and password and access to the protected sections of the association's website or application which contain any notices, records, or documents that must be electronically provided. 2. A current copy of the following documents must be posted in digital format on the association's website or application. A. The recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. B. The recorded bylaws of the association and each amendment to the bylaws. C. The articles of incorporation of the association or other documents creating the association, and each amendment to the articles of incorporation or other documents. The copy posted pursuant to this subparagraph must be a copy of the articles of incorporation filed with the Department of State. D. The rules of the association. E. The approved minutes of all Board of Administration meetings over the preceding 12 months. F. The video recording or a hyperlink to the video recording for all meetings of the association, the Board of Administration, any committee, and the unit owners which are conducted by video conference over the preceding 12 months. G. A list of all executory contracts or documents to which the association is a party or under which the association or the unit owners have an obligation or responsibility and, after bidding for the related materials, equipment, or services has closed, a list of bids received by the association within the past year. Summaries of bids for materials, equipment, or services which exceed $500 must be maintained on the website or application for 1 year. In lieu of summaries, complete copies of the bids may be posted. H. The annual budget required by S. 718.1122F in any proposed budget to be considered at the annual meeting. I. The financial report required by subsection 13 in any monthly income or expense statement to be considered at a meeting. J. The certification of each director required by S. 718.1122D4. B. K. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated condominium association or any other entity in which an association director is also a director or officer and financially interested. L. Any contract or document regarding a conflict of interest or possible conflict of interest as provided in SS 468.4335, 468.4362B6, and 718.30273. M. The notice of any unit owner meeting and the agenda for the meeting as required by S. 718.1122D3, no later than 14 days before the meeting. The notice must be posted in plain view on the front page of the website or application, or on a separate subpage of the website or application labeled Notices, which is conspicuously visible and linked from the front page. The association must also post on its website or application any document to be considered and voted on by the owners during the meeting or any document listed on the agenda at least 7 days before the meeting at which the document or the information within the document will be considered. N. Notice of any board meeting, the agenda, and any other document required for the meeting as required by S. 718.1122C, which must be posted no later than the date required for notice under S. 718.1122C. O. The inspection reports described in SS 553.899 and 718.3014P and any other inspection report relating to a structural or life safety inspection of condominium property. P. The association's most recent structural integrity reserve study, if applicable. Q. Copies of all building permits issued for ongoing or planned construction. R. A copy of all affidavits required by this chapter. 3. The association shall ensure that the information and records described in paragraph C, which are not allowed to be accessible to unit owners, are not posted on the association's website or application. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the association's website or application, the association shall ensure the information is redacted before posting the documents. Notwithstanding the foregoing, the association or its agent is not liable for disclosing information that is protected or restricted under this paragraph, unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. 4. The failure of the association to post information required under subparagraph 2 is not in and of itself sufficient to invalidate any action or decision of the association's board or its committees. This concludes the readout of pages 9 through 26 of the comprehensive 92-page House Bill 913 PDF document. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. Thanks for watching. For full access to our comprehensive reports, statistical charts, virtual monthly meetings, and exclusive meetup events, we invite you to join the Miami Condo Investing Club at Miami Condo Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. An added benefit of the club is that members receive discounts on all Miami Condo Correction walking tours. Please visit miamicondoclub.eventbrite.com for a schedule of upcoming tours. To view additional videos, please visit Miami Condo Club. This concludes our video.